The litigation was registered by Summer Service in January 2017 and alleges Trump Card defamed her following she charged him in an October 2016 news story meeting of sexually assaulting her in 2007. Trump Card's lawyer, Mark Kasowitz, is attractive. The March 20 governing by New York High Trial Judiciary Jennifer Schechter, who permitted the instance to go striker. The go was anticipated, and Service legislative crew plans to struggle it. Trump Card's lawyers had registered a movement to sack the instance, disputing for a December 2017 listening how a CEO has immune of such a lawsuits in country courts and how the instance would dispute in his formal duties, arguments how Schechter sacked. The crew as well reasoned the CEO's common denials of accusations done by Service and other were secured policy speaking by the at first correction since they were statements of view, and reason as well sacked by Schechter. Kasowitz wants the appeal trial to again visit the question of if the basic law's leadership paragraph stick a country trial of listening and activity versus a meeting CEO, inviting it a key question. Wherever, as there, a crucial limit constitution question is at share, a remain to allow appeal overview is authorized, Kasowitz writes, after addition, this need for the order, decisive the question of immune up the instance revenue, is of year just enlarged while the side claiming immune is the highest level by the government formal in the nation. Schechter's governing quoted Clinton v. Jones, the 1997 judgment in that the U.S. High Trial detained how a meeting CEO is not immunity of creature sued in Fed trial for informal acts. How instance leftward outdoor the issue of if concerns of federalist and politeness force a various finding for suits driven in country trial. Schechter controlled such a concerns do not hinder the instance of driving striker in country trial. No one is over the act, she wrote. It is populated how the CEO of the joint state has no immune and is object to the laws for cleanly individual acts. But in the 9-page paper registered in the Country High Trials Appeal Department and dated back April 2, Kasowitz wrote how Trump Card will show on circulation how Schechter controlled wrong and marked how in Clinton v. Jones, this in S. High Trial clearly acknowledged how an activity in country trial might really so this a more than irresistible instance for immune. By both of Fed law and the law of the country, how issue must be solved as a limit question up the activity revenue, Kasowitz wrote. How is exactly which the courts did in Clinton v. Jones. Kasowitz told Schechter as well erred on denial the CEO's movement to sack or latency the instance on at first correction perspectives. Trump Card's crew submitted 12 exhibits in supporting of the Remain movement. Such exhibits involve articles spelled by legislative scholars, a Washington position paper on the Clinton v. Jones instance and a Hollywood Interviewer paper on Gloria Allred, before newly one of Service law firm on the instance, intended to show the suitable was politically reasoned. As well turned on amongst the exhibits is backup of a reduced trial governing in Clinton v. Jones how discarded CEO draft Clinton's immune but remaining the instance, anticipated circulation, that Kasowitz is disputing should occur in the instance. The Remain movement cites a episode of further cases in that a suitable was hanging anticipated circulation on the immune question. Kasowitz plans to ultimate the circulation, a engineering period how tool preparation the instance for the magistrate, by July 9, one of lot deadlines set by the trial as portion of the circulation trial. Relying on an treaty registered Monday among Kasowitz and Service lawyer Marianne Meyer-Van, the factual circulation will not be heard before September. Schechter's judgment to enable Service instance to go striker was a considerable growth for a CEO already cladding a litigation by age movie celebrity Turbulent Daniels, who was paid to hold peaceful on her concoction of a concerted case in Trump Card. It could as well outdoor the floodgates for such cases concentrated not on the estimated offense himself, but on Trump Card's answer to the concoction. Trump Card's private attorney Michael Cohen told in a declaration how Trump Card furiously denies any face in Daniels.